A very warm welcome to all our distinguished guests, speakers, and delegates. Today's conference brings together leaders from India and the United States to explore how our legal systems, businesses, and investors can work together in a rapidly evolving global environment. Throughout this half-day conference, we'll be delving into topics that matter deeply to our cross-border partnerships, from regulatory risks to dispute resolutions, to investment strategies and intellectual property in international markets. It is truly an honor to have such a distinguished gathering of legal experts and thought leaders all under one roof. To set the tone for today, it is my honor to invite Ambassador Shri Binaya Srikanta Pradhan, Consul General of India in New York, to deliver the welcome note.
Distinguished guests, ladies and gentlemen, a very good morning. I'm really happy that the Consulate is organizing this event again after a gap of 2 years. We had this event in 2023 and we always received very positive feedback, but somehow we couldn't do it last year. I'm happy that we are doing it again this year. We have today experts from the legal background who would be talking about the dispute resolution aspect. We have experts from India who would be talking about the initiatives that have been taken by India in recent years. As a Consul General, let me give you a snapshot about the economic engagement, because we are primarily talking about the disputes and dispute resolution on the economic tracks. And in that segment, let me give you, kind of a snapshot of what is happening in different tracks of the economic engagement. So coming to the trade aspect, last year we had a trade of $212 billion, while from the United States perspective, it may not be sounding big. From Indian perspective, US is our biggest trade partner. And we see a robust growth both in trade in merchandise goods and trade in services. And particularly in services, we see a bright future. This year, when Prime Minister Modi came to Washington, DC in February, the two leaders agreed to increase our trade to $500 billion by 2030. So roughly, we are going to increase our trade, that's the target, by 2.5 times in next 5 years. And of course, the governments have been now negotiating a trade deal, which would be going to facilitate that. If you look at the institutional mechanism, we also created now various mechanisms. The one that I would like you to pay attention is something called trust. Trust is basically transforming the relationship using strategic technologies, or in other words, now we are engaging in critical technological segments, whether it is biotech, whether it is defense, space, quantum, AI, you name a critical technology sector. Now the two countries are collaborating, working, and trading on those segments. Coming to the investment track, while people see the easily available data, which is the foreign direct investment, and that's roughly $110 billion of FDI from both sides, $65 billion invested by US in India in last 25 years, and about $45 billion invested by India in this country. But I would say that's only tip of the iceberg. If you look at the other investment from this country in India, you would see about roughly $370 billion of investment in our stock market. You will see all major US private equity, venture capital, hedge fund, asset management entities, even family offices now having their investments in India. So some estimates I see which put the total US investment in India today in the tune of $700 to $750 billion. So that's the magnitude of investment we are talking about. The third interesting aspect is the global capability centers. India is now the global leader in hosting global capability centers. I think about 50% of Fortune 500 companies have already their global capability centers, which are being used not only for the earlier low-end work, but now they are being used for product development, innovation, and all high-end stuff. And out of 1,800 GCCs that we have, 1,050 are from United States. And if you look at the number of people US companies now have in India, last year when Prime Minister was here, we had a tech CEO roundtable. I remember the CEO of Accenture, Julie Sweet, she was mentioning that 350,000 employees of Accenture are today located in India. 250,000 employees of Cognizant located in India, 60,000 employees of JP Morgan are located in India, and the list goes on. Like I said, 1,050 US companies have their GCCs in India. And the last one is remittances. Now, when we hear remittance, we assume that we are talking about remittance from US to India, which of course is a big amount. We have 5.4 million strong diaspora, and we receive about $35 billion of remittance from this country, and which is not simple remittance. These are the money which goes into investment into real estate, investment into various entities in India. But we also send 22 to $24 billion of remittance to this country, primarily to educate our children. We have 383,871 Indian students today, which is the largest cohort of international students in this country, and for their education we send this much of money. So I would say, whether we talk about trade, investment, GCCs or remittances, this huge amount of economic exchanges, economic engagement between the two sides that are happening. And when we talk about such a magnitude of economic engagement, then of course there are issues about risk and risk mitigation and trade dispute, investment dispute and their litigation. Like I said, we have distinguished panelists today from India who would be speaking on this issue. Dr. Rakesh Sharma, who has been leading this for last few years. In fact, he organized the event last time. This time also he has taken the lead. He has got a beautiful panel today. But I would only highlight two aspects in very brief. One is the insolvency and bankruptcy code. Because I for 5 years worked in the oil industry in India, and I have seen how foreign investors, particularly from this country, would come and complain about the IBC insolvency and bankruptcy code. And in last 9 years, I take pride to say that we have billions of dollars of worth cases which have been resolved with the insolvency and bankruptcy code that came in 2016 in India. And so to put it in other words, now if we have an American lender or a private equity fund or a strategic acquirer coming to India, he is not flying blind. He knows that there is a mechanism to take care of his issues. And the second one, which we are today talking about, is India International Arbitration Centre, IIAC. They are actually co-organizer of this event today, and we'll have a detailed discussion about that. But I think in last 3 years of this institution being set up, it's doing a commendable work. Now they are increasingly hearing disputes and provide resolutions. And to sum it up, I would say the message from India is very clear, that India wants to be seen not only as a destination for manufacturing of semiconductor or building AI talent, but we also want to be a credible seat for high-value dispute resolution in our own right. And I'm sure today's effort is to bring the details of that aspect and to create a win-win value for both sides. And with that, let me thank you for joining us early morning and for your attention. I also see a judge, Jennifer Coe-Groves. A real pleasure to welcome you here. Thank you.
Thank you, sir, for the insightful welcome and for your continued support in fostering the Indo-US collaboration in the legal and investment sectors. Before we begin with our discussions today, we will commence with the lighting of the lamp, a traditional Indian custom that signifies the dispelling of darkness and the illumination of knowledge and wisdom. May I now invite our esteemed guests to join us on stage for the ceremony. Ambassador Binaya Srikanta Pradhanji, Dr. Rakesh K. Sharma, Mr. Atul Sharma, Ms. Eileen Breslin, Judge Koi, please join us on the stage. Ladies and gentlemen, please help me welcome them with a round of applause, please. May this light inspire meaningful dialogue and collaboration throughout the day today. Thank you, guests. We now move to our virtual keynote session titled India Transcends, International Arbitration Hub, delivered by Hon'ble Justice Hemant Gupta, Chairman of the India International Arbitration Centre and former Judge of the Supreme Court of India. Justice Gupta's address will highlight India's growing prominence in the global arbitrations landscape.
Good morning, Mr. Manish Kulhari, other distinguished guests, esteemed legal practitioners, visionary business leaders, and friends. It is an honor to address you today in a conference organized jointly by the Consulate General of India in New York in collaboration with India International Arbitration Centre. I, as a chairperson, welcome you on behalf of India International Arbitration Centre in this conference, which is about Indo-US legal sector, investment and dispute resolution. India stands at the cusp of transformative chapter in its evolution and its deepening of its strategic partnership with the United States. The economic partnership between India and the United States is a dynamic and has consequential bilateral relationships in the world. According to the Office of U.S. Trade Representative, bilateral trade in goods and services between our two nations reached an estimated $212.3 billion in 2024, an impressive growth of 8.3% over the previous year. In the fiscal year 2024-25, bilateral trade in goods alone reached around $132.2 billion, with India maintaining a healthy trade surplus with the United States. The US has now emerged as India's largest trading partner, reaffirming the strategic depth and mutual interdependence of our economies. Yet, these are not statics. Behind every number lies a human story, a story of collaboration between innovators, entrepreneurs, professionals, and policymakers across diversified, involving diverse jurisdictions and sectors, supported by progressive legal reforms, institutional strengthening, and a judiciary increasingly aligned with the global best practices. India is emerging as a preferred seat and venue of arbitration, combining procedural efficiency with cost effectiveness and cultural neutrality. This evolution signals a broader ambition to position India as a bridge between East and West, offering a forum that embodies both international sophistication and local accessibility, making it a natural choice for the businesses seeking reliable, transparent, and equitable dispute resolution. India's transformation is from aspirational to achievement. There are several factors to explain this transformation. Firstly, the legislative reforms which strengthen the framework, such as mandating strict timelines for arbitral awards, 12 months from the date of completion of pleadings, confidentiality of proceedings and impartiality of arbitrators, institutional arbitration accreditation of arbitrators. The unique concept which is invoked in India is Arbitration Consul of India, tasked with grading arbitral institutions. I understand there is no such parallel institution anywhere else in other jurisdictions. India's higher courts have reinforced the pro-arbitration stance. In 2024 alone, Indian courts delivered several landmark judgments emphasizing party autonomy and minimum judicial intervention. Earlier in 2012, in Bharat Aluminium versus Kaisar Aluminium, the dispute between Indian company and the US company was governed was signed to be governed by English law, with London as the seat of arbitration. The court held that the seat of arbitration determines the procedural law and supervisory jurisdiction, emphasizing party autonomy and choosing it. It ruled that Part 1 of Arbitration and Conciliation Act applies only to the arbitration seated in India, and Indian courts lack jurisdiction in foreign seated arbitration except at the stage of enforcement under Part 2. Consequently, no interim relief or injunction under Section 9 was found to be maintainable for such arbitration. Infrastructure development has been at the heart of arbitration reform's journey, though the establishment or strengthening of premier institutions such as India International Arbitration Centre, the only statutory institution in India, the Delhi International Arbitration Centre, and Mumbai Centre for International Arbitration, and many others, India has made significant strides in creating world-class institutional framework that rivals the most established global arbitration hubs. These institutions are not merely administrative bodies, they represent India's commitment to excellence, transparency, and procedural efficiency in dispute resolution. They offer state-of-the-art hearing rooms, digital case management system, and a comprehensive support services designed to meet the expectation of both domestic and international parties. Together, these institutions are helping India's transition into new era of institutional arbitration, where efficiency, predictability, and credibility defines the process. This evolution underscores India's readiness to serve as a global hub for commercial dispute resolution. Taking the vision forward of making India a hub of arbitration, India International Arbitration Centre was established in the year 2019 and as an institution of national importance. We have created state-of-art facilities that provide parties with modern hearing rooms, advanced technology infrastructure, and professional case management services. The premises are designed to facilitate complex multi-party international arbitration with the efficiency and discretion that parties expect. IIAC follows the best international practices for maintaining effectiveness and efficiency in resolving the disputes. IIAC have a diverse panel of arbitrators comprising distinguished legal minds from India and around. For example, we have around 250 arbitrators impaneled, out of which former judges are 66, advocates are 97, engineers are 34, the service arbitrators are 27, chartered accountants are 4, company secretaries 5, cost and work accountant 2, others 15. In respect of international arbitration, we have 48 advocates, 21 former judges, engineers, architects, chartered accountant, company secretary, and many arbitrators are of different nationality other than India. That gives the variety of international arbitration which is available for choosing the parties to choose an arbitrator. Cost effectiveness remains one of India's most compelling advantage in the global arbitration landscape. India offers world-class arbitration service at a fraction of the cost typically incurred in traditional arbitration hubs such as London, Singapore, or Paris, without any compromise on the quality, integrity, and sophistication of the proceedings. The country benefits from the competitive professional fee, lower administrative and logistic expenses, and robust pool of highly qualified arbitrators, lawyers, and institutional experts trained in both domestic and international international practices. Actually, investment and dispute resolution are the two sides of the same coin. Investment inflows were particularly strong in manufacturing, financial services, communication, and energy, sectors that collectively form the backbone of India's growth story. However, every dollar of investment brings it with not just opportunity but responsibility. The responsibility to provide a predictable, fair, and enforceable dispute resolution framework. Investors require the assurance that if disagreement arises, they will be resolved impartially, efficiently, in accordance with the rule of law. This confidence forms the bedrock of long-term investment relationship. Among other factors, India has positioned as an alternative to traditional arbitration seats, but as a dynamic, credible, and globally competitive hub for resolving cross-border commercial disputes, particularly between Indian and American entities. The outlook for India-US trade and investment remains robust, with cross-border commercial activity and foreign direct investment expected to grow steadily. As this flow deepens the demand for sophisticated, efficient, and predictable dispute resolution mechanism will continue to intensify, requiring arbitration institutions that can handle complex, high-value international cases with expertise and neutrality. We are committed to meeting that evolving demand. We stand at the heart of this transformation, embodying India's resolve to provide a neutral, transparent, and efficient forum for dispute resolution. Our mission extends beyond facilitating arbitration. It is about building trust in India's legal ecosystem, bridging jurisdiction, and promoting confidence in cross-border commerce. As India and United States deepen their economic and strategic engagement, our legal and institutional cooperation must keep pace together. Together we can establish a model for cross-border dispute resolution that reflect the shared democratic value and commercial dynamism of both nations. In this journey, we extend a warm invitation to our friends and partners from the United States to join hands with India in shaping the next generation of global arbitration practices. Let us co-create a future where disputes no longer divide the businesses, but are resolved through fairness, dialogue, and shared respect for the rule of law. Together, we can make the Indo-US partnership not only cornerstone of the economic growth, but also a benchmark for international dispute resolution excellence. The future of arbitration is collaborative, inclusive, and increasingly Indian in its address, but global in its spirit. With these words, I thank you all for giving me a patient hearing on this important topic of international arbitration in India. Thank you very much.
We now begin with our first panel discussion of the day, cross-border transactions and disputes, India and US. This discussion is going to explore regulatory risks, jurisdictional challenges, arbitration versus litigation, and the intricacies of navigating contracts in a complex environment. Please join me in welcoming our guests, Dr. Rakesh K. Sharma, Senior Attorney and Founder, Draft & Craft, Mr. Atul Sharma, Executive Chairman, Dentons Link Legal, Ms. Eileen Breslin, Partner, Gunnercooke US LLP. I'm going to request Ms. Eileen Breslin to start the presentation.
Greetings, everyone. I guess this is working. Let's see now. Okay. What I'm going to discuss, and I know there's a lot of lawyers in this room, so I think I might be, when you're coming, I'm talking about inflow, when you're an Indian business or businessman considering either a joint venture or investing directly in the United States, really the very kind of first thing you want to think about is the legal and regulatory framework. I assume that's the same for people going in the other direction, but certainly it is here. There's a very complex compliance and you can not evade, but avoid a lot of it by picking the correct structure. The structure you pick to invest will largely determine what it is you'll be subject to. And regulatory compliance everywhere, including the United States, is extremely complex. It is governed by what industry you're investing in, what type of investment. Are you selling to the public? Are you selling stocks? Are you doing a joint venture? So every single step of the way, you're making a decision, a legal decision. So you really want to get your advisors on side very early in the process. Because you might decide, maybe I'll do it a different way and have less of a burden, or less, not such a new burden. Obviously, there's a kind of preference, I guess, for doing things that other people have done before and works. It just makes it a bit simpler. And as you can see, there's lots of ways you can come into the United States. You can just export stuff, you can license stuff, you can franchise, and I think other people are going to talk about these in detail. Maybe you'll just form an alliance, joint venture, or maybe you'll really be a big investment, one of the $1 billion investments, and you'll actually build your own factory, probably in South Carolina. But as you can see, all of these have different ways to do it. Maybe you'll do it contractually, maybe you'll have equity, maybe you'll do it as a loan. So, this is a very, very simplified version of all the things you're going to want to think about when you decide to come in. Now, after you've come up to something, you've decided, okay, I found a partner, I like them, I'm either going to put money in their company, or we're going to start a company together, or, whatever the structure is going to be. It is very important to do your due diligence. Super important. Everybody's nice, everybody's friendly, but you really want to see financial statements if you can, and depending on where they are in the process, they may not have the financial statements you'd like to see, but certainly you're always going to want to go out and, as they say, kick the tires. They have a factory in Omaha. Fly out to Omaha. Have a look at it. Is it a real factory? Is it a bake shop? Well, if you don't go, you don't know. And you don't have to go yourself. There are people you can send. And I know there are some services provided by people in this room that can provide a lot of due diligence. And now there's legal due diligence, there's accounting due diligence, there's engineering due diligence. But you want to step back and say, what is it I want from this partner, from this investment right now? And that's what you want to examine the most closely. That's what you want to see, okay? If it's finances, if I'm investing in them because I think they're running a great business, you want to look at their numbers. And you want to make sure they're good numbers. And you want to maybe even have your own auditors looking at it. On the other hand, maybe it's just a great idea. They've got a great AI program in, healthcare, law, whatever. Well, then you want your engineers to look at it. You want to look and see, do they have a patent? Do they have a patent pending? By the way, just because they have a patent pending doesn't mean it's any good. So you want to have your own patent people looking at it and say, A, they're going to get something, likely. They can't tell you they will. And B, it's going to be worth something. There's literally hundreds of patents on clothes hangers. So, getting a new patent on a clothes hanger, probably not worth that much money. Only a specialist can tell you that, okay? So due diligence, that's a general word, but think of it as a whole field in and of itself. Then you're going to move on to the contract, and there's always a contract. If you're buying stock, it's going to be a stock purchase agreement. If you're buying assets, it's going to be an asset agreement, maybe a franchise agreement, maybe it doesn't really matter. You know, there's some piece of paper where you're going to write down what it is you think you're giving, what it is you think they're getting, and what happens if things go wrong. Now, in this one, I'm almost going to give you the exact opposite advice that I gave you on due diligence, which was to hire an expert and make sure they know what they're doing. In a contract, whatever it's called, you should be able to understand it. If you read your contract, A, you don't know what it says, that's a problem. You assume you know, you're all smart, you're all here. Anybody who's investing internationally is reasonably well educated and they're reasonably smart. Now I know you've all heard of Warren Buffett, and he wrote the introduction to the SEC's plain language, plain English guidelines. And then he writes, you know, imagine you're writing to your aunt. You know, she has no particular education, but she's not stupid, and she manages her own money, and she's a reasonably intelligent adult. She should be able to read this and know what it means. If she doesn't, there's a problem with the way you've written it. Never think it's you. If you read a contract that somebody's asking you to sign and you don't understand what it means, stop. And say, I don't understand this. I want it written plainer. And also, you want to be sure not only you understand it, that God forbid it ends up in a dispute, the arbitrator or the judge understands it, and he understands it the way you understand it. And so with contracts, you really want to be sure you know what you're writing. And also you want to have something called force majeure. What happens if 9/11 happens? What happens if, unbelievably, somebody hits the Suez Canal? You know, things you never thought were going to happen, and yet do. What's going to happen then? Now, dispute resolution, nobody wants disputes. All contracts, particularly all shareholders' agreements, are kind of prenuptials. When people get married, they want it to work out. Most of them are hopeful. Most of them think it's going to be happiness ever after, but sometimes it isn't. Okay? And you want to, at the beginning, say, what if things go wrong? Now, dispute resolution, you will have already taken care of it a little bit earlier, right? When you made sure you understood your contract, when you made sure everything you wanted was in there, when you made sure everything was plain, and you talked to the guy on the other side. In my experience, there are some sleazy characters, but most people are reasonably honorable. A lot of times they're dispute because people really didn't understand what they were agreeing to. You saw A, they saw B. So when you get here, you want to ask yourself, how should we resolve disputes? Now, one we just heard about was arbitration, and I tend to favor it. I'm actually on the IIAA national panel because in business, people want things that are fast, and they want things that are, and I use this word advisedly, inexpensive. Nothing's inexpensive. No dispute is ever inexpensive. But relative to litigation, arbitration is inexpensive. You're dealing with maybe an engineer if your dispute is over engineering. Maybe you've provided in the contract that if it's a financial, XYZ accounting firm is going to decide whether this meets the provisions. And I know I don't have to tell you that before you sign that contract with that dispute resolution, you talk to somebody at XYZ accounting firm and say, is this what I should have? Is this what it should say? I want to be sure if they say they have making this amount of money or their machine does whatever it does, it really can. So in that case, arbitration, I think, is better You can do that. You can say, I want an engineer to decide this case. I want a lawyer to decide this case. I want, a patent lawyer to decide this case. You can do that in arbitration. You can't in the courts. In the courts, you go with the judge you get. At least in New York, it is long, it is expensive. I have had clients who had to really, in my opinion, they had a good case, but they had to walk away from it because, only $50,000, $60,000, $70,000 was involved. You can't litigate for something that's small in New York, but that's real money so you can think of that and do it. So you want to say, how will we do it? Will it be arbitration? Mediation is where the arbitrator actually tries to make a deal. Arbitration, they're neutral, like a judge. And litigation, it is the law, the contract says what it says, it has certain things. They're all good. Litigation, you have the right to appeal. And as you see in the paper now, constantly, people keep getting judgments and they keep appealing it, and they go all the way up, and some of them end up at the Supreme Court. That's not true in arbitration. You all agree that what the arbitrator decides, end of the road. Now, there are exceptions if you can prove bias, but you should assume, if you go with arbitration, that what the arbitrator says, end of the discussion. Not so in litigation. So that's a benefit of litigation. You want to measure it, you want to see the amounts involved, you want to see how much flexibility you need, and then you want to decide. Now, in the case of an international investment, of course, you're going to be deciding, do I want Indian law? Do I want U.S. law? And if I want U.S. law, as I'm sure many of you know, if not all, you're going to decide what state. Do I like New York State? Do I like Delaware? Everybody used to like Delaware, and now I guess a lot of people like Texas. But you could say, I want a New York court to decide it based on English law. Absolutely can do that. You can say, I want arbitration in Hong Kong, and I want to use Indian law. Absolutely can do that as well. But you got to think about it. People refer to these provisions, dispute resolutions, venue, choice of laws, as boilerplate. Oh, it's just the back of the document, it's the same. It's not the same. It is very important that you understand what you're agreeing to, and you assume you are going to be one of the unhappy couples that ends up in divorce court. Okay? And how will I want this to work out in these disputes? Now, since the gentleman who spoke before me already talked about the investment benefit of coming into the United States, I won't tell you again, but they're huge. The money's huge, the benefits are huge. It's very stable, the legal system's pretty well settled, arbitration is very well understood, people expect disputes, they know how to handle them. I suspect from what I heard that is the same in India. Where the fights are going to be is, well, I want to go to India, well, I want to go to New York. Don't have those fights. That's a fight you have when you're all friends, before you put your money on the table. That's when you make those decisions. And then when the fight comes up, you just do it. And that's what I will say to you. Does anybody have any questions? No questions? What? Okay, then yes. You, yeah.
Thank you. So my name is Sanjit. I work with Deutsche Bank here. So you mentioned that a lot of people used to choose Delaware as a place to incorporate, and you spoke about the whole thing with regards to due diligence as well. So without going into why people want to go into Delaware now or not, where would you suggest other states which are equally incorporation friendly apart from Delaware? I know you mentioned Texas, but are there other states which are equally provide the same benefits that Delaware would?
I like Delaware law. I know people pick Texas now because they're allowing things that, are tricky in Delaware. But since I think almost all businesses, not all disputes, but almost all businesses are better off in arbitration than they are in court. Delaware law, in my opinion, is very fair and very well understood. And I've heard somebody say, this is not original thinking, that if you knew nothing about the law and there was a dispute, and you didn't know what Delaware law was, but you knew fair from not fair, you knew right from wrong, you could probably guess how a Delaware court would find, how that would turn out under Delaware law. It's logical, it's sensible, it's what you expect. Now, I don't know, Texas could be great too, but everybody's not as familiar with Texas as they are with Delaware. You'd have a hard time, I think, finding any corporate lawyer who didn't have some familiarity with Delaware contract law. And that's what you want. You want what's understood. I know, that it's prejudice against the new guy, but yes.
Just related to what he said, his question was, Delaware and now Texas, especially after Musk, that pay package case has become very popular now. But the question is, Delaware as well as Texas, they are favorable from directors' liabilities point of view. But what about shareholders' point of view? Which state you prefer from shareholders' point of view?
Well, the thing that's gotten Delaware, I guess, into trouble is that they're, I guess, protecting shareholders, as you mentioned in the case of Elon Musk, from what some people consider a wild salary. He's worth every penny, I'm sure. But again, with shareholders, as with everything else, and I have nothing against Texas, I know what the shareholders write in Delaware. In fact, if you were to have New York law, it's much more protective of shareholders than Delaware is. If I'm representing a relatively small company, a minority shareholder, I'm probably better off with a New York company in New York. Delaware is kind of what people call there's no widows and orphans. You were a big boy. You had the right to get a lawyer. Did you sign it? Yeah, you signed it. So
Then I would say from international business point of view, I believe that New York is the best place.
what's the best place?
I said New York is the best place from international business point of view.
Yes, well, New York is the best place for courts. And what a lot of people do, because New York judges are very sophisticated, and a lot of people will pick Indian law, but decided in a New York court. And New York courts will do that. You have to have some contacts, but you do. But everybody does. Yes, New York courts are very popular.
So what's your opinion about Nevada?
Nevada is also a very good jurisdiction. Nevada was going to be the Delaware of the West 10 or 15 years ago. But I would say if I were in California, I might pick Nevada, but I'm in New York, so I pick Delaware. But Nevada's got fairly, sensible laws too. The point for all of you is to say, well, what business am I in? Now, I was at the City Bar Association last week, and there are some insane number of new privacy laws just in New York, like hundreds. You're going to get swept into that. And a lot of other laws, health laws. So you want to say, what industry am I in? What state is good for that? What country is good for that? India might be better for innovators, and the patent holders may feel that New York is better. That's what you want to say. Who am I? What am I doing? What's my investment? And remember, you have a lot of choices as long as you make them in the beginning. At the end, not so much.
Hi.
Yes, hi.
My name is Sri Jiripalli, and I'm a co-founder of a business advisory firm, and we also do US-India cross-border transactions, pretty much at that upper end of the beautiful graph you had there,
Yeah.
joint ventures, M&A. So a bunch of our agreements do have arbitration clauses, especially, companies in India who are coming over here, want to do a deal here. Now,
over time, we've seen, different flavors of those, clauses, binding arbitration or choose one arbitrator, So what are you seeing these days? What's,
Depends on the size. If you have a relatively small investment, $1 million, $2 million, whatever, probably one arbitrator is enough. Binding, they're neutral. If you go to the AA or the India one that we just heard about, they're going to have neutral people who are going to consider it. The problem with 3, which is the second most popular, is usually one side picks one and one side picks one, and then they pick the third. Okay, so now you have almost 2 sets of lawyers, right? You're going to hire your lawyer anyway. It's cheaper to have one. On the other hand, if you're going to have a really complex situation or it's a big deal, you probably want a panel. You want different expertise involved. So it depends on your deal.
So sometimes it happens that you have to cover up. The program gets late, so we got to sandwich the things. So probably, there are so many questions to be asked, but I'm pretty sure that we'll have the opportunity back again. So as far as the US perspective, we have just understood that how the businesses, how the dispute resolutions can happen vis-a-vis US entities, US jurisdiction. My take is in respect of India, that how India is stepping out and how things are shaping up and how we are taking things ahead. So let me just give an idea about it. The previous presentation, you would have seen a lot of images, and mine you are going to see a lot of data, a lot of things to understand, to talk about. So primarily what I'm going to focus upon is that how India is coming up now, and we see that how the FDI is growing in India, and how the inflow has been actually been built upon in the last 25 years. So 900 billion since 2000, and how the US investment is coming to India, how things are shaping up. If you recollect, Hon'ble Justice Hemant Gupta had said that taking a penny doesn't just come as an investment, but it also comes as a responsibility. So do we take it in India now? Then we can see that how market size has been increasing, how demographics have been multiplying, and digital revolution, and we can boast of having coined the digital payment module, which is unique across the globe. We call it UPI. So that's how India has shaped up in digital technology. And this revolution is everything, but is nothing if we don't ease out for the businesses to come to India. So there are 2 important things, the risk and the reward. My friend was just talking about it. So we are in India trying to minimize the risk and maximize the reward. And probably that's what it is, ease of business. For that, in past we have done a lot of reforms, though I'll come straight away to the commercial courts. India was known for the time when we used to have litigation spread over decades. But now we can boast of commercial courts, where the 2 years is the maximum time limit within which the cases are to be closed, decided. And of course, FEMA, there was a time when the foreign exchange problems were considered as a criminal offense. We shifted it to the civil because somebody invests money, so it cannot be penalized vis-a-vis some criminal intent. There cannot be any mens rea in that. So we shifted it to the civil offense penalties over there. Of course, companies, we have made a lot of changes so that the governance can match up, governance can move up. And of course, the insolvency and bankruptcy. So it was always believed that the bankruptcy extends to an unimaginable days, the longer periods. So it's been limited now by section 12 to 330 days. That's the maximum time limit we have. After that, If it doesn't happen for whatsoever reasons, it goes straight away to the bankruptcy forum. And then we have the Arbitration Act. So IIAC has been the prominent position by India. A huge infrastructure has been built upon. A lot of arbitrators have been pitched in. We heard Justice Gupta sharing it with us. He's heading it. And not only that, we are also growing now sooner to become an hub where any languages people will be communicating through the arbitration. So the Digital India is trying to map it up with the IIAC in time to come. So somebody from the Spain with the Spanish language, one businessman from Spain, the other coming from India, or any other jurisdiction. So this would be again a unique combination which IIAC is likely to offer sooner. Apart from that, of course, we have come up with automatic routes which covers 90%, which are the automatic approvals passed on. So the government intervention decreases to a very larger extent. And of course, when we talk about a comparative part, we all know that how cross-border enforcement happens. So just a glance of it. So we see that arbitral awards is the most acceptable forum now. So we prefer to go to the arbitration, and IIAC happens to be the place where we can bank upon with minimum cost, best results delivered. Then, of course, timeline 6 to 12 months. And we have made so many reforms so that the implementation of awards actually happens in India. It's not just something in here. These are the basic key reforms, as I just stated, that the key reforms being the commercial courts. So we have 12 months goal to finish off, maximum it stretches to 24 months. So the litigation ends, the arbitration awards gets implemented. Then we have the Arbitration Act, time limit, public policy is narrowed. So in a way, of course, I'll not get a deep dive into this. My friend has already discussed onto that, how the due diligence and contract drafting happens. Of course, they always have a prime importance, especially when we as a lawyer understand their value, that what is not written, we miss it. Now, best way to resolve, though primarily we don't say when somebody takes up an investment, starts a venture, makes a technology transfer to any jurisdiction, the likelihood of the dispute should be minimum, but you never know. So dispute resolution strategy has to be pitched in. So we have early quick case management, assessment and everything. Then of course cost benefit, because you don't end up spending what probably you're not going to get. So the cost effectiveness is very important. And when we talk about the evidence, how evidence are to be preserved, how they are to be looked into, and how different experts gets involved into this. Then we have the compliances audits. So then proactive communication and maintain institutional relations with the regulators. So these are some of the takeaways which I'll say that we need to have from this conference we are having, that India is not somewhere in behind, India is on the front. So we are now looking after a good relationship with our more investors, more arbitrators based in US. Primarily, I generally say that we start our relationship with the people with namaste, and then we do a handshake, and then we hug. So slowly from the namaste, we are moving to the hug. So I'm sure that this bond is going to deepen and we'll have a very strong relationship coming ahead. So these are the few things. I'm just making space for my friend Atul Sharma to come, because he's got 10-15 minutes more to talk about. Please come. Atul Sharma represents an Link Legal, a law firm which entered into a very dynamic relationship with Denton, and I can boast of that their organization is the only organization so far which has entered into a wonderful alliance with Denton. Welcome.
Thank you, Rakesh. I'm delighted to be here. I think Dentons is a living illustration of how within a compliant structure, notwithstanding the fact that we have not had a very liberal regime for law firms entering into India, that we have been able to adopt a structure which works to the benefit of both the international community as well as the Indian businesses. We have had a rundown on what the opportunities so far as India is concerned are on offer. I would like to now talk about, and keeping in view the theme of this conference, which is investments and disputes, I would just like to make 4 or 5 important points, because when we lawyers start getting into legalese, I think this is never ending, and we have this tendency of getting deeper into the, and I think I can speak that on behalf of Judge Klo as well, because I was talking to her and I was saying that what happens is that in the present geopolitical situation, in this din of the trade issues, we should not be losing the focus on the opportunities that India affords. If we look at what has happened in India in the last few years and where India is positioned today, I think I may not be wrong in saying that today where India is, China was 20 years ago. And one of the key requirements of the Indian community, Indian population, Indian businesses is infrastructure. The infrastructure has not kept pace with the development. We all know the data. Rakesh has given the data as to where we are. We are an only economy which is growing at 6%. We're going to be the 3rd largest economy. That's all something which is in public domain. But I think the thought leadership today, when it comes to India-US businesses, or maybe for that matter, India international businesses, is that we should not lose focus of the key investment areas. And if you look at these investment areas, the key pace with the changing geopolitical environment. I'll come to that bit a little later. But the fundamental issue here is that we need not forget and need not let the opportunity be clouded by the geopolitical issues. And this whole din of trade disputes is something which is just taking center stage and pushing the whole agenda of India's growth back. From an infrastructure perspective, if you look at the regime that we have had in the last 20 years, I can say with certainty, and I'm saying that with some experience, well, I have had the opportunity of being associated with about, at least the last 20 years, about 200 big projects in the infra space. And I have my colleague James Newland sitting here from Dentons. And we have had this discussion, and there was a delegation to India with him a few months ago. The opportunity that sits there with the liberalized PPP regime is something which you just can't miss out on. I can say with surely that the PPP regime that India has is one of the most liberal regimes. What it affords is a regulated, quasi-regulated, quasi-judicially regulated regime of return on investment and return on equity. If you look at the reforms that we have had, in the telecom sector. I think the front runner was telecom. In fact, it started with electricity. It failed in this first avatar. And then the Electricity Act came later, but then the revolution had started with telecom. So Telecom Regulatory Authority, followed by the Electricity Act, and that was a liberalized regime to an extent that Supreme Court of India has said that what is not prohibited is permitted. So a generation is something which you can do without a license. For distribution and transmission, you do need licenses, but you can generate power in any part of the country and transmit it to any part of the country. As a result, the electricity power exchange came in being, and you could sell your electricity like a commodity in the exchange. Followed by the highway liberalization, we have a regime which is kind of expecting about 50,000 crores of rupees in the next 5 years coming into this sector. India is the only country which has 9 privately operated airports. And I had the good fortune of being associated with about 7 of them domestically and internationally. The Airport Economic Regulatory Authority. Then you have the port business. You have now a huge opportunity in the data centers and the GCCs. So this is how the country has kept pace with the expectation of the businesses. And we should not lose sight of this piece, which is very, very important from a viewpoint of what we need to set down as the agenda for foreign investors. Coming to the other structural reforms, one of the key reforms which has happened is insolvency. And we have not been able to focus substantially on acquisition of stressed assets. That's a great opportunity sitting after the amendment, the 2016 IBC Act, and how the assets which have been stressed, actually the whole thing was driven by the state of the banks. So what we call it the dirty dozen. There were 12 banks who were the first ones who were, their debts had reached a level where the government thought that unless we resolve this piece of the debt structuring, we will not be able to bring back the banking system to really assist the businesses. So dirty dozen was the 12 large banks which were subjected to large cases, which were subjected to a review through the National Company Law Tribunal, as a result of which today we have the number of years that it takes to resolve the stressed asset and the insolvency. So a call had to be taken as to whether the asset should be sold or the asset can be reconstructed. And the whole process has really given a fillip to the stressed asset revitalization program. The third aspect on the business side is the national monetization plan. There are a large number of assets which have been conventionally run and operated by the government. The government has, as a structured program, placed it for privatization under the PPP model. And it contains a whole lot of assets, including financial assets, banks, privatization of banks, investments in banks, assets which are hard assets, as I said, airports, ports, and the like. This is so far as the opportunity on the business side is concerned. Coming to the reforms, as I said, apart from the fact that there have been reforms in the statutory mechanisms for development of infrastructure, the general reforms in relation to arbitrations is something which has taken center stage. There has been this controversy as to whether the Indian court system is geared up to ensure that the arbitration awards which are rendered by the tribunals internationally, in international arbitrations as well as domestic arbitrations, would they be enforced in a timely manner? we don't have a solution here in the sense that you have to have in international disputes and arbitration as the dispute resolution mechanism. The reason being that India doesn't have reciprocity with large number of countries in terms of enforcement of judgment. We have with most of the Commonwealth countries. But then still it has to go through a process of the court looking at the decree or the judgment and seeing that it is not against the public policy of India. But so far as arbitrations are concerned, because India is a signatory to the New York Convention, I think it is absolutely important to understand that there's no alternative to international arbitration, because then you have a standardized regime under the convention to ensure that the challenges to the awards and the consequent enforcement is within a known regime. There's some issue of last year, 73, when the government came out with a notification that beyond a certain limit, we should not have arbitrations. But then I think it's a hiccup, because then everybody realizes that if you have to have international dispute resolved in a manner which is recognized and understood by the community at large, the legal community, the business community at large, you need to have arbitration as the only means of dispute resolution. Now, to enable this, and as you heard Justice Gupta in the morning, there have been various changes which have been brought about in the arbitration law. I don't want to get into the legalese of it. So broadly what it does is bring in the whole controversy with regard to seat and venue to rest. And as per the proposed amendment, of course it's still up for stakeholder consultation. As per the proposed amendment, the distinction between venue and seat will be done away with. So if you have chosen a venue, that will be the seat. And apart from other, Section 9, the emergency arbitration recognition, we didn't have a regime until there was an award from the SIAC in the case of one of the big retail groups, Amazon, and there was no regime available to us. Supreme Court said we'll recognize an emergency arbitral award and enforce it. But notwithstanding that, the proposed amendment wants to bring in the recognition of an emergency arbitration award. Focus on institutional arbitration is going to be a key, and that's why when Justice Gupta was here, he focused on the relevance of institutional arbitrations. Now this is, sometimes it so happens that because people start comparing with SciTech in China, because that is a statutorily government promoted body. And here you have a statutorily set up under the India International Arbitration Centre Act, the Arbitration Centre. But we should not forget that the regime is only administering the disputes, and it is not a substitute for the dispute resolution. Still recognizes the basics of an arbitration, and therefore we should not mix up the two, because this is only an international arbitration institution. I am now, for example, I'm one of the arbitrators who's impaneled on the international panel. We had entered into a capacity building exercise with the center. And on the construction side and the infrastructure side, we needed to have a bank of arbitrators who were trained, who were domain experts, who had also dealt with construction and construction and infrastructure disputes. We worked closely with the center, did certain training programs, along with in cooperation with the Royal Institute of Chartered Surveyors. We created that bank of arbitrators, and some of the numbers which he mentioned include those arbitrators who are internationally competent, domestically competent in the domain areas of construction and infrastructure. So these are some of the steps which will go a long way in giving the confidence to the investors as that notwithstanding an element of delay, because what has happened is the award process is very fast. It's 2 years to 2.5 years. But the enforcement gets entangled in the civil procedure code issues, because the attachment has to be under the local laws, because the award is treated as a decree of an Indian court. We have had some changes, particularly in the public sector awards, because the public sector has been asked to put money in the court, because if there is a delay in enforcement, then the award is only as good as it's the paper written on it, because you need to realize the dollars or the rupees underlying that award. That's an area where the courts have been very proactive, and they have been asking for the judgment, the award debtors to pay up money, deposit money in the court. And most of these awards are essentially tested in the larger courts of Delhi, Mumbai, Hyderabad, Bangalore, and Chennai. I think which have been very liberal. Delhi High Court has been a front runner. The next legal issue is the cross-border recognition of intellectual property. I think one of the most liberal regimes, excellent cross-border recognition judgments have been given out by the Indian courts, and the regime is as good as anywhere in the world. These were the few 4 or 5 points I wanted to talk about, because I can go endlessly. There are a large number of reforms which have happened and which can ultimately be a very significant part of the growth story. But the bottom line today is, don't ignore India. You need to recognize the fact that that is the opportunity for the next decade. Thank you.
So do we have any questions for any of the panelists? Anything, if anyone wants to ask? Yes, please.
Right. So I have a quick question for Mr. Sharma. Sir, so you mentioned that the insolvency regime has been doing really well in India, and then you also alluded to how well the new arbitration regime works. So, on a lot of cross-border investment transactions that we do into India, a lot of our stakeholders, a lot of people ask, should we put in our insolvency disputes also to arbitration, or do we leave it to local insolvency law? So what would be, your, I wouldn't say advice, of course, but your train of thought with regards to that?
No, I think we need to understand two fundamental distinctions here. Firstly, arbitration is a private dispute resolution system. And secondly, anything which goes to the insolvency court is essentially a proceeding in rem. So any private or even a bi-party dispute resolution in a court is essentially going to affect only two parties, right? The plaintiff and the defendant. However, in the case of an insolvency petition, for the purposes, because it is not a means of recovering money, let's accept that. And once it leads to what we call as the CIRP process, the appointment of the resolution professional, then the company is virtually taken over by the resolution professional. And if there is no resolution plan by a third party which comes up for resurrecting the company, then it leads to liquidation. So you have to be choosy. You need to make an assessment of what the financial health of your debtor is. What will be the consequence of your ignoring a bipartisan process and go to a general in-rem remedy. I believe sometimes it is used as a pressure tactic. It has also been used because, in fact, there was an amendment which was brought in 29A. Originally, what was happening was it was a complete no-no for the promoters of the same business to take advantage of insolvency and get the debts reduced and then come back through the back door. That has been, in a way, done away. But still, in certain circumstances, you still have the usual bankruptcy law issues with regard to related party transactions, the look-back period. But all in all, the regime has worked well because, you see, most of the banks were public sector banks who had great exposure to, and unless those debts became standard from doubtful or you had to make provisions. So to that extent, this has enabled the banks, which were public sector banks, to take a view which they could not have taken otherwise at the board level, to ensure that they are happily taking a haircut and looking at the long-term perspective of the business.
Thank you. Very, very interesting. Thank you.
Hello, my name is Prashanti, and this question is for Eileen. We were talking about incorporations and where to incorporate a business, and I do immigration law and also some company law, especially where it applies to India, bringing companies from India to the US. And everyone wants to incorporate in Delaware, right? No matter where they're living, but they're not actually doing business in Delaware. They have their office, say, in New York. So then, does it make sense to still incorporate in Delaware, or should they be incorporating in New York where they're actually doing business?
Well, the decision, can you hear this?
Yeah.
Okay. To incorporate in Delaware, and it might also be true of, I think someone mentioned Nevada or Texas, is you want to take advantage of their corporate law. New York corporate law is interesting. It allows for dissolution, involuntary, if you have, I think it's 20%. It makes shareholders responsible for certain debts. So people don't like New York law because they don't like the corporate law. So even if they're, I'm not making a qualitative judgment there, that's mostly the reason. But even if you're going to operate in New York, a lot of people want to incorporate in Delaware because they like the laws. Now, you'll see shareholders agreement of, a Texas corporation that says, this will be governed by New York law. No, it won't. If it's a New York corporation, it's going to be governed by New York law. Its contracts might not be, but that corporation is going to be governed by the law of the jurisdiction of its formation. And again, people like Delaware law because it's reliable. They know what nobody likes. If you do this kind of law, there's nothing we hate more than surprises. We want to know what we're going to get.
So, so then would you just register to do business in New York?
Yeah, you become
as
a foreign corporation.
Okay, got it.
Even if you're doing it, and again, the question you raise is choice of entity. In New York, you have publication, which you will if you want to qualify as well, but it depends on your business. Yeah, you just qualify in New York as a foreign corporation.
Thank you, Eileen.
Thank you very much. Okay, please. I think my friend has got a question. Yes, please.
I have a question for you, Mr. Sharma.
Please.
You mentioned that enforcement of foreign judgments is not there in India unless you relitigate the case there. What about principle of comity and principles of reciprocity? Say, for example, in United States, all 50 states have that implemented enforcement of foreign judgment awards. So if United States is accepting a judgment given by a court in India and they are enforcing it here, why can't a judgment given by United States can be enforced in India?
Probably we confuse when we talk about the judgment and the award. The judgment passed by court in the US are not enforceable in India. So is the case a judgment given in India is not enforceable in the US, but awards are. That's why we are saying we need to go for the arbitration. Because awards are different. The awards passed are in reciprocity, implemented, executed.
No, but United States courts, they do accept judgments given by a foreign country in United States.
Section 12 FRCP, I think, Section 13 prohibits it that the judgments of the civil courts of other jurisdiction are not executable in US unless it is allowed in reciprocity. So, yes, please, you take that.
I think we need to understand to understand this issue, so far as reciprocity is concerned, the Indian Civil Procedure Court, Section 13 recognizes the jurisdictions which have signed up for the reciprocity. How a judgment is enforced. So as Rakesh said, the legal position is that US judgments cannot be enforced in India as a judgment. Likewise, an Indian judgment cannot be enforced in US as a US judgment, a judgment of a US court. But what typically happens is that when I get a judgment of a US court for enforcement in India, I have to bring an action based on the judgment in the nature of an original proceeding, which is a suit. And likewise, I suppose in US. I'm not a US law expert, but I assume that's the position in the US as well. So when you're referring to enforcement of a judgment of an Indian court in US, it is not enforceable as a judgment of a US court, but certainly there is a presumption that there is a judgment which has been rendered by an Indian court and you can bring in an independent action. And it's only in certain circumstances that the judgment will not be honored in US.
My understanding is there's a difference between to relitigate the case or to get the foreign judgment enforced. These are two different things.
So relitigation is not on merits. So when you talk of relitigate, it is not on the merits. That's why I said the presumption at both ends is that there's a judgment. It cannot be set aside except in certain principles which are well recognized. For example, due process. If you've not been given a fair opportunity, that could be a ground for not.
So it's only in case of default judgment that happens in United States also. If you obtain a default judgment in New Jersey and you try to enforce in New York, you cannot do that because that's the default judgment. But if a judgment was given in New Jersey on merits, you can get it enforced in New York. Same way, if a judgment was given on merits in India, you can get that judgment enforced in a court in United States.
By an independent action based on the judgment, not
Yes.
as not
to relitigate.
Yes, not to go on back to the merits, but at the same time, the distinction is an award is treated as a decree, as against a judgment of a foreign court in this case will be taken as a judgment which will be the basis of your original action for enforcement. I'm sorry, I'm getting a little too legalistic here, but that's the subtle distinction.
Can I chime in here real quick? So I think what this gentleman is referring to is that there are foreign monetary awards that are enforceable in the US in certain states. So, and those foreign monetary awards could be via judgments in different countries, including India. So if you look at New York, Illinois, California, and there are a handful of other states that enforce foreign monetary awards. But what the courts would look at is they would do a procedural kind of review of the judgment to make sure that the court that awarded the monetary award had the jurisdiction, it's not against public policy, but it's short of relitigating the case in the US. So it's called Uniform Foreign Monetary Awards Act.
Right.
Something like that, but I think that's what you were referring to.
Yes.
Is that right?
I'm sorry, in fact, we are stretching out the session to a longer part. We have got very good sessions in time to come. So let's have a 10 minutes break. If we'll still be left with any questions, we are here to answer them. Please, thank you very much. And